morning everyone. In the last video lecture, I have discussed with you the evolution of the international migration law. So I have already told you that it has evolved since back to 1919. The ultimate the exact origin from where the international migration law has been originated, it is still untraceable. As you know that even international migration law is it doesn't have any single legal framework, but it is an umbrella term from which takes the various principles, rules, and regulations from the various numerous branches of the international law. That is like international humanitarian law. Then you have got the consular law, the maritime law, the refugee law. So you see that this international migration law, it doesn't have any single framework. When we don't have the single framework, even there is the origin and the evolution also is quite it is difficult to find out from where it has originated. But yeah, it is it has been it has been said that it has been evolving since 1919, and it is still evolving. It is in the process. It has not been completed. It has not reached its zenith. So you see that as we have divided how the evolution has taken place into four historical periods, and yesterday I have discussed with you the first historical period, and that is your early migration governance. Okay, and that is 1919 to 1989. In that particular period, what happened, you can see this these are very you have to remember various conventions, treaties while you read the evolution of the international migration law, because it is quite related to various conventions. International law is generally the main source is the conventions and the treaties. So you'll have to remember the various conventions and treaties which have time to time it was established for dealing with the matter. So in the similar manner, there were various treaties and conventions which led to the evolution of the international migration law. Since in the first historical period, that is your early migration governance, as I have already discussed with you, and I hope you have gone through that video lecture where and also in the class also I have discussed with you that what happened in the year 1919, there was soon after the Second World War, there was League of Nations was established. It also worked quite very hard to deal with the matter of leading with the migration, because it has introduced the passport regime, which is considered to be a valuable travel document among the nation states. And complementing this, the League of Nations High Commission for Refugees also, it has granted the refugee status on a group basis, and it granted the Nansen travel documents to allow the displaced by the collapse of empire free passage across Europe. Meanwhile, the International Labour Organization also concluded a series of labor rights conventions which were increasingly applied to migration. So you can see the role of various conventions, you have got the League of Nations, the League of Nations High Commission for Refugees, then you have got the International Labour Organization, moreover the UNHCR for dealing with the Palestinian refugees. You had your United Nations Relief Works Agency for Palestine refugees for dealing with the issue of the Palestine refugees. Then UNHCR, that is United Nations High Commission for Refugees, was also established during that period to protect and find solutions for the European refugees, because there has been migration of various from the various non-European countries to Europe, and there were a lot of European refugees. For dealing with them, there was also this convention. This office was established, that is the office of UNHCR, that is United Nations Human Commission, a High Commission for Refugees. Meanwhile, one of the most important organization, that is PICMI, the Provisional Intergovernmental Committee for the Movement of Migrants from Europe, came into being, which later on became ICM, that is International Committee on Migrants, which later on became IOM, International Organization of Migrants, in 1989. This is also a very important organization which is working continuously to deal with the migrant issue, because international migration law is all about the migrants, the refugees, the asylum seekers. So we have to deal with every aspect. Now see, during the time there was even during that time of early migration government, that is the 1919 to 1989, there was also a Cold War. So And this refugee governance also provided a means to the Cold War entrance, serve Cold War entrance, whether for the refugees moving from east to west or across borders. So, and this picnic also took a very logistical role over this. And by the end of the Cold War, a number of things had changed in the nature of migration. During the year 1980s, increasing number of people had started to move transcontinentally, and millions were displaced as a result of recently ended Cold War conflicts. So you can see a changes due to the end of the Cold War. So this was all about the first historical period. I already discussed it. That it was just a revision for you guys. So second historical period, or you can see how this international migration law has evolved. The second stage, a historical period, is your taking stock period, and that is from the year 1994 to 2006. You know that 15 years after the Cold War were characterized by the reluctance of the northern, predominantly migrant receiving states to bring migration into the United Nations. So you see, there was a reluctance by the of the northern countries, predominantly migrant receiving states, to bring migration into the Union. This in turn, contributed to proliferation of new actors, initiatives, working groups, dialogues, and reports on migration-related issues in the year 2000. And this multilateral system's main achievement during this period was to take stock of the state of existing norms and institutions for dealing with the migration issue. So you see that it was the sending receiving divide. So there was a reluctance on the part of those migrant receiving states, and moreover there was multilateral system was to take care of, to take stock of the like existing norms, whether there is any existing norms relating to migration and institutions. So you see there was a sending receiving divide. Okay, the earliest mention of this you can see about the UN International Global Intergovernmental Conference on International Migration appears to be in a resolution adopted by the General Assembly. So on December 1993, this particular resolution, General Assembly passes the resolution, and this particular resolution is convening of a UN conference for the comprehensive consideration and review of the refugees, returnees, displaced persons and migrants. It invited recommendations to the Secretary General on the appropriateness of convening such a conference. So you see that, like after taking stock means what? Like this was the period of taking stock, whether there is any existing norms and institutions. Moreover, the General Assembly passed a resolution for the comprehensive consideration and review of these refugees, the returnees, the displaced persons and migrants. Apart from that, there was the Cairo Conference on the Population and Development took place in the year September 1994. And international migration, it figured prominently on the agenda. So you see, these conferences and conventions became so important that migration was the main agenda to it. However, you can see that polarization between predominantly migrant sending and receiving states led to deferral of the debate about organizing a possible conference on migration and development, because you see that there was movement from east to west, north to south, non-European countries to European countries. So there was a divide between sending and the receiving countries. So there was a lot of conference being held which deals with the migration issue. And after this resolution, which was passed by the General Assembly, there was like following this resolution, the member states were surveyed on 4 occasions. So you see that in the year 1995, in the year 1997, 1999 and 2003, and concerning their views on an international conference on international migration. So you see, like this particular, after passing of the following the UN General Assembly resolutions, the member states, we know there are a lot of member states of the UN, and they surveyed on the 4 occasions, that is in the year 1995, 1997, 1999 and 2003, and their concerns were on view on the international conferences on international migration. And on each occasion, you see when they conducted the survey, it was found that there was reluctance by the migrant receiving countries to bring migration into the Union. And while this distinction between the countries of immigration, emigration and transit is often blurred, in reality in cases where all 3 kinds of migratory movements prevail in a single country. And the only significant new multilateral treaty to emerge on migration after the Cold War was the International Convention on the Rights of All migrant workers and their families. So this was one of the most significant multilateral treaties to emerge on the migration, because you know that treaties or conventions play a very important role in international law. So most significant, that is after the Cold War, because we are talking about we are in the second stage, historical period, you can say, taking stock, and that is after the Cold War. And this was the International Convention on the Rights of All Migrant Workers and Their Families of 1990. But by 1999, the report of the Working Group of Intergovernmental Experts on the Human Rights of Migrants documenting a regret that the National Convention on the Rights of All Migrants, Workers and the Families had not yet entered into force. It led to the creation of the mandate of the Special Rapporteur on the Human Rights of Migrants appointed by the UN Commission for the Refugees, or sorry, UN Commission for on Human Rights. So you see that this significant multilateral treaty, and this was an important multilateral treaty, and but in the year 1999, and uh, there was a lot of working groups who works under this convention, and this they documented a regret that ICRMW, that is the International Convention on the Rights of All Migrant Workers and Families, they had not yet entered into force, and it led to the creation of the mandate of the Special Rapporteur on the Human Rights of Migrants appointed by the UN Commission on Human Rights. However, even after entering into force in 2003, following its ratification by a sufficient number of primarily migrant-sending countries, the International Convention on the Rights of All Migrant against, rights of all migrant workers and their families, non-ratification by the northern migrant-receiving countries, it underscored the North-South divide in multilateral migration governance. So, moreover, this was this there are a lot. This was the period where of taking stock of various norms, institutions, and there was a establishment of various conventions for dealing with the migrations. And so you can see there was a divide, between the sending countries and the receiving countries. In parallel to this north-south divide, a new trend has come up, and that is the trend of the regional consultative process. It ushered in a number of regional and trans-regional networks by the state. It is used by the states for informal dialogue and the sharing of best practice in ways that offered an alternative to formal multilateral governance. So you see that the this is one of the ways to deal with the problem of deal with the issue of migration, and this regional consultative process was one. So there was it ushered in a number of regional areas and trans-regional networks. It was used by the states for the formal dialogue, between the among the states. So the first regional consultative process is widely recognized to have been the International Consultation on Asylum and Immigration. It was created in 1985 by 16 destination countries in the industrialized world, with a permanent secretariat in order to facilitate information sharing, initially in relation to asylum and now increasingly in relation to migration in general. So you see this regional consultative process has been playing a very vital role in for the migration issue too. The purpose is not to develop formal or binding agreements, but to facilitate the development of best practice, information sharing, and the addition of common standards. So this model, notably during the 1990s and 2000s, with the help of the International Organization of Migration, it support to practically every region in the world with the development. For example, you see, sometimes in international field we have got the in the central level we have, but we are divided. There is a three-tier government block. We have got the district level, village level. So in this manner, it becomes easier to deal with the situation. So in the similar manner, this regional consultative process was being established to deal with the issue of migration. For example, the regional consultative mechanism for Central America, Mexico, and the US, the Budapest process for Eastern Europe, the Bali process for Australia and Southeast Asian states, the Colombo process, the Abu Dhabi process, the Mediterranean 5 plus 5 process, the international dialogue on migration in West Africa, and the international dialogue on migration in Southern Africa. So you see, all this has helped with dealing with the problem of migration. And many of the early RCPs, such as the the Budapest process, the regional consultative process, emerged sui generis, being the initiative of the participating states. There were a lot of other dialogues. For example, the regional dialogues in South African, RCPs, such as in uh, you can say in various areas, various places of the world, there was regional consultative process been going on regarding the issues of migration. And against this backdrop, the early 2000s were also characterized by a increased recognition of necessity for some kind of multilateral governance architecture to manage both the migration within and beyond the UN, and taking us, a stock taking of which building blocks were already available. So in his report, so there was a need of the multilateral governance, because there was no such multilateral governance in this field. Moreover, you see, there was substance but without architecture. You can see that, because there were a lot of conventions, a lot of this regional consultative processes being going on, but still there was no exactly. You cannot say there's one framework where we get the evolution part, or where we get the governance from where we are to be governed to the problem related to the migration of the refugees, or we cannot get a proper significant in a one form. So you see that number of initiatives which sought to consolidate the existing norms and a legal framework relating to migration. And one of these was that the Birds Initiative, publication on migration and international legal norm, and ILO's multilateral framework on labor migration. So you see the Birds Initiative and the ILO's, that is International Labour Organization, multilateral framework on labor migration. They non-binding principles and guidelines for a right-based approach to labor migration. It surveyed the existing norms and legal frameworks. They contributed to the recognition of international migration law as an umbrella heading for all public international law relevant to migration. And this process, it was complemented by the creation of a myriad of deliberation on different aspects on what a desirable and feasible agriculture for global migration governance might look like. So it is including the IOM's international dialogue, that is International Organization on Migration's international dialogue, UNHCR's global consultative process, the Hague Declaration on Future of Asylum and Migration Policy of 2002, the establishment of the Geneva Migration Group 2003, and the Burns Initiative International Agenda for Migration Management, that is of the year 2004. So you can see that this substances, we can say this is a substance without architecture, because a lot of conventions, a lot of this consultative process were being going on, and there was a lot of groups being formed, and this was what was the reason behind it? It was for the dealing with the migration issue. So, and you can say about the Doyle report too, and all this has compiled to give a picture of the international migration law, so that the migration can be governed. So another is the Doyle report, and the global consultation on consultation process, there was a this particular conventions and this conventions declarations groups, it set the scene for further reflection on the international institutional architecture relating to migration. So in 2002, the Professor Michael Doyle, appointed by the UN General Secretary Kofi Annan and Assistant General Secretary, they published the Doyle report. It laid out a series of options, including creating a new agency, designating a lead agency, bringing IOM into the UN, and promoting issue-specific multilateral agreements, and launching a global commission. So this Doyle report, that Professor Michael Doyle, it created a series of operations for creating a new agency for dealing with the migration. And the option from the Doyle report, it's selected by the Secretary General, was to create an independent expert commission with a small secretariat. So it wanted to give an architecture to it, the Doyle report, that there should be an expert commission with a small secretariat. And the Global Commission on International Migration, it ran from December 2003 to 2005. It held a series of regional constitutions, and it culminated in a report, Migration in an Interconnected World. And this report was primarily thematic, covering trends in areas such as labor migration, circular migration, educational migration, remittances, diaspora engagement. Okay, so you see that it created a new structure. It tried to give a new picture to the international migration law in the global level. And there was also, you know, uh, there was the first high-level dialogue on international migration and development, and it was held in 2004 in UN, as per the UN General Assembly Resolution 58 of 208. It called for a high-level dialogue for the international migration and development, which held in New York on 14 and 16 and 15 September 2006. And this decision to convene a high-level dialogue instead of a more formal international summit was based on a compromise between the migrants and migrant receiving countries, and their agenda focused narrowly on migration and development. And the main area of focus or of the dialogue was the effects of migration on development. There was four main roundtables of the dialogue, and this was the effects of migration and development, measures to ensure respect for protection of human rights of all migrants, and to prevent the combat smuggling of migrants and trafficking in person. Thirdly, the multidimensional aspects of international migration and development. And fourthly, the building of partnership, capacity building, and sharing of best experiences at all levels, including the bilateral and the regional levels, for the benefit of countries and markets migrants like. So you see, there was also high-level dialogue which are on international migration and development, and this was during the third phase, and it happened in the year 2006. So this is the three phases, and like we'll discuss more on it in the next video. So in the next class, I'll be discussing on this. The second period, the second historical period, which is the taking back stock 1999 to 2004. You see, thank you.